This is English shorthand dictation number 318 and the dictation speed is 120 words per minute. Ready? Start. When the trial in court is over, the judge should proceed at once or as soon as possible to the consideration of his judgment. If the judgment is not pronounced at once, every endeavor shall be made by the court to pronounce the judgment within 15 days from the date on which the hearing of the case was concluded. But where it is not practicable, the court shall fix a future day for the pronouncement of the judgment, and such date shall not ordinarily be a day beyond 30 days from the date on which the hearing of the case was concluded. If the judgment is not pronounced within 30 days from the date on which the hearing of the case was concluded, the court shall record the reasons for such delay and shall fix a future day on which the judgment will be pronounced, and in every case the due notice of the day so fixed shall be given to the parties or their pleaders. It is necessary that the judge should proceed to the consideration of the judgment while the demeanor of the witnesses and their individual characteristics are fresh in his memory. He should bear in mind that his first duty is to arrive at a consensus conclusion as to the true state of those facts of the case about which the parties are not agreed. The oral and documentary evidence adduced upon each issue should be carefully reviewed and considered in the directions. Some judicial officers make a practice of prefacing judgments with a memorandum of the substance of the evidence given by each witness examined, which has to be referred to. This practice is irregular when the memorandum is in addition to that made under Rule 8 of the Code of Civil Procedure. All that the law requires is a concise statement of the case and not a reproduction of the evidence. The judgment should, however, be complete in itself as regards the requirements of Rule 4 of the Code, and should set forth the grounds of decision as concisely as is consistent with the introduction of all important matters. It may be necessary in the particular cases to refer to and give a summary of the statements of a witness or witnesses, but if so, such summary should be incorporated in the reasons given for the decision of the court on the issue to which it relates. When it is necessary to refer the evidence of a witness in the course of a judgment, the reference should be by name as well as the number of the witness. Instances have occurred of judgments not being written until a considerable time after final arguments in a case have been heard. This practice is open to grave objection, and in any case in which judgment is written and pronounced within 30 days from the date on which arguments were heard, a written explanation of the delay must be furnished by the subordinate court concerned to the district judge. This is not meant to encourage a practice of reserving judgments. On the contrary, judgments should ordinarily be written as soon as arguments have been heard. It is only in the exceptional case where the court has to consider many rulings and cannot conveniently give judgment at once that there is any justification for judgment being reserved. In the preparation and delivery of judgment, civil courts have to follow certain directions. The judgment should be written either in the language of the court or in English. When a judgment is not written by the presiding officer with his hand, every page of such judgment shall be signed by him. It should be pronounced in open court after it has been written and signed. It should be dated and signed in open court at the time of being pronounced, and when once signed shall not afterwards be altered or added to, save as provided by section 152 or on review. If it is judgment of any court other than a court of small causes, it should contain a concise statement of the case, including the points for determination, the decision thereon, and the reasons for such decision. If it is the judgment of a court of small causes, it should contain the points for determination and the decision thereupon. It should contain the direction of the court as to costs. All the paragraphs of the judgment should be serially numbered to facilitate references. The judgment should be pronounced as soon as possible after the case has been heard. Where it is desired to pronounce at some future date, the court shall fix a day for that purpose and inform the parties accordingly. Every endeavor shall be made by the court to pronounce the judgment within 15 days from the date on which the hearing of the case was concluded, but where it is not practicable to do so, the court should make all efforts to pronounce it within 30 days. Otherwise, the court shall record the reasons for such delay and shall fix a future day on which this judgment will be pronounced, and due notice of the day so fixed shall be given to the parties or their pleaders. The judge need not read out the full judgment. He can pronounce only the final orders. However, the copy of the whole judgment is to be made available for the perusal of the parties or their pleaders immediately after judgment is pronounced. The judgment may be pronounced by dictation in open court to a shorthand writer if the judge is specially empowered by the High Court in this behalf, and is to be dated and signed by the judge. In appealable cases where the parties are not represented by their pleaders, the court should inform the parties present in court as to the court to which an appeal lies, and the period of limitation for the filing of such appeal, and place on record the information so given to the parties.